Good morning, everybody. Welcome to Division 1 of the Court of Appeals. It's nice to see so many people in attendance for one of our oral arguments. We have two oral arguments at 9 o'clock, scheduled at 9 o'clock this morning. The first one is White Law versus the Denver City Council. I see council are seated and ready to go. The second case that we have is Dolan versus the Fire and Police Pension Association. Are counsel here for that case? Okay, we will hear argument second in that case. However, after this first oral argument, we're going to take a brief recess to reconstitute the division. I want to let you know that we're pleased to be joined for the first oral argument by Senior Judge Leonard Plank. And so he will join us for this case. I will briefly review our procedures. We have 15 minutes for each side for oral argument. As the lawyers are aware, we have a digital timer, so you know how much time you have left. We also have our traditional timer that starts green. It turns to amber when there are 5 minutes left and red when your time is up. The counsel for the appellant can reserve some time for rebuttal argument. As you know, the judges have read the briefs, and at least one of us has had an opportunity to review the record, and because of that, you may wish to focus your argument on the legal issues rather than the facts. But of course, how you present the argument is up to you. You should know there's a toggle switch on the podium that you could raise or lower at your convenience. You should also know that we're live streaming the oral argument. And it will be archived, I think, starting tomorrow, so you will be able to see it later on if you so choose. And finally, I would ask everybody to check to see if you have a cell phone with you to make sure that it's turned off so it doesn't inadvertently interrupt us during the oral argument. So with that having been said, we're ready to hear the oral arguments in White Law versus Denver City Council.
Good morning, and may it please the court. My name is Greg Kerwin, counsel for the appellants. My attorney number is 14161. The Denver Zoning Code and the Due Process Clause are the people's protection against arbitrary zoning changes by a city to help a private developer, and that's why we're here today. If you were teaching a course in administrative law, this case would give you a textbook example of how not to do it right, where a court should set aside administrative action for at least 3 reasons, and I'll get into these in addition to answering your questions during the argument. First, the Denver Zoning Code has mandatory requirements for a zoning change, all of which must be met, and 3 of them were not satisfied here. There is no adopted plan calling for this high-density development on Crestmoor Park. There were no justifying circumstances showing the character of the area had changed. And the city admits that it does not consider traffic and parking problems when considering rezonings in the city. You should be astonished by that. That's the city's official policy. The second reason, and this is procedural, is the procedures the city followed here failed to meet the basics of due process. There were undisclosed ex parte communications with the developer's lobbyist. Now, the cities and the developers say, oh, you can confirm the substance was all in front of the hearing. We don't even know today the substance of all of the communications, some of which were by telephone, and there were no affirmative disclosures by the council members at the public hearing, as should be the case and is normally the case with courts and with federal administrative bodies. So we have rampant ex parte communications. We have quasi-judges who explained their decisions based on irrelevant political factors. We have a current planning board member, somebody whose job it is to decide whether a zoning is proper, serving as the zoning applicant, which had to have an effect, a common sense effect on the planning board. And we have large campaign contributions. And finally, and this is more technical, there's no basis for deference to the city's legal interpretations here. The issues that we're presenting are legal issues concerning the interpretation of the Denver Zoning Code, and this court should review that de novo. So to protect the fairness and the integrity of the administrative process, the court should set aside the zoning for both substantive and procedural reasons. If you set out to advise the Denver City Attorney's Office to design a fair quasi-judicial rezoning process, it would not occur this way. And this reviewing court should not rationalize a way to justify the actions that did occur here. So in the short time today we have, I want to address any questions that you have and discuss the three major points that I raised about flaws with the rezoning.
Mr. Kerwin, can I ask you a quick question at the outset?
Please.
Are you appealing the district court's denial of the declaratory judgment? Is that part of your appeal?
It is, Your Honor.
Okay, thank you.
And the standards from this court about what is reviewed under Rule 106A4 and Rule 57 are fairly clear, although I think there's some room for judgment here. It appears that sometimes with legal issues, this court puts those into a declaratory judgment standard in Rule 57 rather than Rule 106A4. But our complaint asserted claims for both. The brief on the merits that the trial judge denied addressed the declaratory judgment action, and we're appealing her entire ruling.
Thank you.
So our major concern on legal issues is the Denver zoning code and what constitutes an adopted plan. All over the city, there are specific plans for specific neighborhoods when development is contemplated. There is no specific plan for this neighborhood because it has been stable. What the city and the developer bring to you instead are generic strategies from a citywide plan where there's no specific statement in that plan that this strategy should apply to any particular parcel. And indeed, as we argue in the briefs, those general strategies could apply anywhere in the city. That's the way that the city says it complied with the mandatory criteria of consistency with an adopted plan.
Mr. Kerwin, doesn't a zoning plan have to encompass the entire city?
Well, Your Honor, a zoning plan in Denver has three different levels, and they have a comprehensive plan, and it does encompass the entire city. They have Blueprint Denver, which is the second level, which also encompasses the entire city and designates areas of change and areas of stability. This is an area of stability. And then Blueprint Denver, Chapter 8, specifically says for particular neighborhoods, we want to provide specific guidance. So a zoning plan adopted by entities that have authority to do it, which here's the Denver City Council, certainly encompasses the entire city, but it would be meaningless if it didn't provide specific guidance for specific areas. And in this case, the 2010 zoning code was adopted as a legislative enactment after extensive public hearings to get input. And the rezoning of this parcel called for single-family residential in just 2010.
So are you saying to us that taken together the comprehensive plan and the blueprint plan are insufficient to establish guidelines for rezoning here?
They could, but they don't here, Your Honor. If they said something about this area that was meaningful, that allowed this development, then yes. Blueprint Denver calls this an area of stability and suggests that there won't be major changes. So Blueprint Denver, standing alone, does not support what the city wants to do.
But doesn't Blueprint Denver, when it discusses areas of stability like the development here, indicate that there, or like Crestmoor Park neighborhood here, indicate that there can be areas for infill development?
It does, but this doesn't meet those criteria, Your Honor. To have fair notice to the residents when they buy property of what to expect with zoning in their neighborhood, a city plan like Blueprint Denver should tell them, and Blueprint Denver doesn't tell them that. That same language for infill development could end up in any residential block anywhere in Denver, and that's the problem here as a matter of law, is the city is construing the adopted plan requirement to be meaningless. And yet the adopted plan requirement exists in the zoning code to protect citizens from arbitrary zoning changes. So we're asking the court to apply a reasonable common sense meaning of the adopted plan requirement, and don't let a generic strategy like what you've just referenced in Blueprint Denver suffice. It allows for decision makers, administrative decision makers, to do anything they want to without predictability. There's two other requirements in the zoning code that are also at issue here. The city must show justifying circumstances where the character of an area is changed. And all that happened was the church on this parcel was dilapidated. The previous owner wasn't maintaining it. That didn't change the character of the area. And that criteria, also mandatory in the zoning code, should require that this zoning not be approved because there were no justifying circumstances.
Well, I'm not clear about your position about that, Mr. Kerwin. Given that apparently there was agreement that the church on this site was in poor condition, does that not justify a modification or doing something to that parcel of land?
Not to put high-density apartment buildings with 75 units to replace the church. And the church was still in use. It hadn't been painted. It was a dated kind of thing that there were weeds growing on the lot. But it isn't something that meets the statutory criteria of changed conditions to an area. And again, we suggest as a legal matter, the court should not give the city carte blanche to change the zoning just because a property owner chooses not to maintain its building. You can imagine the mischief that would create. Anybody who wants a zoning change, first task is let your building go to disrepair, because that will justify the zoning change. The third mandatory criteria is the public health and safety. And it is remarkable that the city admits, and they do quite squarely in their brief, that their official policy is not to consider adverse traffic and parking problems, when obviously, if you increase density, as they're doing all over Denver, that will create traffic and parking problems. And that, we suggest, is a classic example of arbitrary interpretation by the city. Let me touch briefly on the procedural issues, and then I want to try to reserve some time for rebuttal. There's a lot of discussion about ex parte communications here. It would not be proper, if you were functioning as quasi-judges deciding this, you wouldn't consult with the applicant 6 months in advance about strategy. You wouldn't talk to them 4 months in advance about how to mediate a solution. You wouldn't be conferring with the developer about how to maximize his chances for success by changing the date. You wouldn't be talking with the party 1 and 2 weeks before the hearing to get information off the record in a telephone. It is common sense for judges, and you know it, and you would never do it. You shouldn't apply a lower standard for quasi-judges. And the case law here is a little bit dated and involves some different circumstances. We rely heavily on a PUC case from the Supreme Court from almost 30 years ago and the Zuvase case from this court. But the ex parte communications that occurred here can't simply be written off as non-substantive because there was no discovery. There were no affirmative disclosures by the city council, something we would argue should change, perhaps as a result of your ruling, where when council members come into chambers, they say, I want people to know I've had the following communications with developers. That's the norm with judges in the Code of Judicial Conduct. That's the norm with federal administrative agencies, and it should be the norm in the Denver City Council.
Do you agree with the Supreme Court's determination in the Manassa case that the Code of Judicial Conduct does not apply to quasi-judicial proceedings?
I don't think it's for me to agree. That's clearly what they said, but that involved an IME physician, Your Honor. We don't need just the Code of Judicial Conduct to apply, but it certainly provides relevant guidance. And you're correct, that is what they say, but I think involving the fairness of an IME physician as a quasi-judicial decision maker is not the same as a council member serving as a quasi-judge. And then finally, there's a lot of talk in the briefs about the presumption of integrity, and yet this court's decisions are quite clear that if there's a conflict of interest or other standards that don't indicate honesty and integrity, that presumption doesn't apply. The record here with campaign contributions, with ex parte communications, and with a sitting member of the planning board serving as zoning applicant all take away that presumption and instead create a de novo review situation.
Mr. Kerwin, I have a question about remedy. Assuming that we agreed with you on many or most of your positions, are you asking us to direct the city to reverse the zoning change and reinstate the original zoning? And if so, how does that affect what's going on the site right now, if anything?
The answer is yes, that's what we're asking for. I would call it a remand. I don't think that would preclude a further zoning change under appropriate criteria with fair procedures. What's going on the site right now is the developer is moving as fast as he can to build townhomes, and there are 3-story townhomes towering over the street. We would return to the district court and ask it to stay, if this court were to grant the relief that we seek, until a fair hearing can be held to determine what proper zoning is there. And that's a risk the developer takes. We did not get a stay. We can't afford the bond to do it. But if a developer proceeds with an action like this pending, he proceeds at his own risk. I've got about 3 minutes. I'm going to try to reserve that for rebuttal unless the court has other immediate questions right now.
Very well. Thank you, Mr. Kerwin. I see there are 2 counsel for the defendants. Do you intend to divide your time? And if so, how?
I'll address that, Your Honor. May it please the court, good morning, Chip Schoenberger on behalf of Metropolitan Homes. For purposes of today's argument, I'm going to handle the defense side arguments. I have with me at council table here Tracy Davis, who represents the city. So I will do my best to handle all the court's questions and all the arguments on the defense side, unless the court has specific questions for Ms. Davis or the city that go into the nuances of their internal procedures and things of that nature.
Okay, thank you for that clarification.
Your Honors, I think it's important to clarify, and this touches on a question that Judge Navarro asked early on in Mr. Kerwin's presentation, that the scope of this 106 appeal, and I disagree with Mr. Kerwin about the declaratory judgment being an issue in this case. First of all, it wasn't briefed that way. The standard of review that was set forth in Mr. Kerwin's brief was strictly about Rule 106. Also, I would point out that the complaint allegations, although they contain two causes of action, they were almost entirely overlapping, and Judge Gilman handled them primarily under the Rule 106 standard. I think the only outlier that wasn't totally overlapping might have been the traffic issue.
But I'm sorry to interrupt you, but didn't Judge Gilman also say that she was denying declaratory relief?
She did. And I think because the nature of the allegations and the way the case was presented was talking about reversal of the City Council's decision for the various reasons articulated in the brief. So I think Judge Gilman was treating these, as happens a lot of times in Rule 106 cases, these issues as sort of a singular attack on the zoning decision, on the legal basis presented. So in a Rule 106 context, first of all, Rule 106 isn't a vehicle for launching constitutional attacks on the entire zoning proceedings or on the entire municipal code or the zoning code, or even to lobby for legislative change in that respect. Rule 106 has a very limited purpose, and in this context, it is to address the City Council's final decision with respect to this particular rezoning under an abuse of discretion standard within the context of the statutory framework that the City Council operates. Now, the plaintiffs have raised a number of issues which are addressed in our brief. I'm going to focus my limited time today on the due process and the review criteria issues. As to due process, there is no dispute that due process applies in a quasi-judicial context. And there's also no dispute that a handful of emails went to Councilwoman Sussman that weren't disclosed in the public record before the hearing. But all due process questions really boil down to a matter of fundamental fairness. And so the question before the court is whether or not including those emails in the public record deprive the plaintiffs of fundamental fairness in this proceeding. And the simple answer to that is no, and that's because the emails that we're talking about had no impact on the case at all. Irrespective of who sent them or even what they said, there is no evidence in the record that anyone other than Councilwoman Sussman ever even saw these emails, let alone relied on them. They only went to Councilwoman Sussman, and she actually voted no on the rezoning.
Mr. Schoenberg, what is your response to the contention in the plaintiff's briefs that even though Councilwoman Sussman voted against the proposal, she was actually lobbying other council members to vote in favor of it?
Well, my response is that that's pure speculation on the plaintiff's behalf. There's no evidence of that at all, and we can't reduce a due process inquiry into a matter of speculation. That would open the door for anyone to raise the specter of a due process violation based on their mere speculation that something terrible might have happened behind closed doors. It would allow parties to inject a safeguard due process time bomb in quasi-judicial proceedings in case they lose. You can't simply speculate as to what might have happened. Our case law says that there has to be actual evidence of bias or conflict.
Well, let me ask you as a follow-up to that. Related to that, the neighbors contend that they were unfairly denied the opportunity to conduct discovery to see if there were, in fact, additional emails or communications between council member Sussman and other council members.
They did ask for discovery in the district court, and that was denied. That has not been appealed as far as I can tell in the briefs. There's no discussion of it. It's not listed as an issue. There's no discussion of the case law that Judge Gilman relied on in making that decision. There's no analysis of the standard of review, which is an abuse of discretion under evidentiary issues. It simply isn't before this court on the briefs. So at the end of the day, the plaintiffs were given ample opportunity to present all of their arguments, all their opposition in a lengthy public hearing. And the mere fact that the public record didn't include emails that City Council itself never even saw doesn't render those proceedings fundamentally unfair. And the case law bears this out when it describes and looks to materials that have an actual impact on the case. That was the situation in Colorado Energy. It was the situation in LG Everest and the situation in Zuvich, which I'm probably mispronouncing, but that's the best I can do.
Mr. Schoenenberg,
yes.
I'm sorry to interrupt you. I have a quick question. Does the record reflect that at the time of the public hearing, does it reflect whether Councilwoman Sussman, was she president of City Council at the time of the hearing? Does the record show? I know that the property was in her district, but I know she was president at some point. Was she president at this time? Does the record show?
Honestly, I don't know the answer to that.
Okay, that's fine.
It might be the case. She certainly was. It was her district.
Thank you.
So in Colorado Energy, getting back to the point of material effect on the outcome of the case, Colorado Energy says that an agency can't base its decision on ex parte communications. And the LG Everest case takes that same concept, but it describes it in terms of influence and substantial prejudice. And here the plaintiffs aren't even, other than the speculation that we talked about, the plaintiffs aren't even saying that City Council based its decision on these emails. They're asking the court to reverse simply because the emails existed in the first place. And there is no precedent for reversing on that grounds in a Rule 106 context. The due process issue also implicates the campaign contribution issue, which the plaintiffs have raised in their briefs. I'll talk about that for just a few minutes. Putting aside the fact that the plaintiff's evidence is nowhere in the administrative record, and the district court disregarded it for that reason, again, there is no evidence that these campaign contributions had any effect on the outcome of the case. They totaled $15,000. They were a year to 2 years before the decision was made in this case. And there's no evidence that it had any impact. Caperton, which is sort of the benchmark that the plaintiffs are using, was an extreme example by all accounts. A $3 million effort to get an appellate judge put on the bench as the litigant's case was going up for review in front of that court. Aside from that extreme scenario, our case law says you have to overcome the presumption of integrity, our case law says you have to show at least some evidence of actual bias. Otherwise, we presume that our quasi-judicial judges are carrying out their duties faithfully. And there's nothing in this record that overcomes that presumption. The last point I'll touch on are the review criteria. And I think Judge Taubman hit it on the head here with respect to how much guidance does the comp plan and Blueprint Denver really provide? Well, we know Blueprint Denver drills down a lot deeper than the plaintiffs would have the court believe. It not only identifies areas of stability and areas of change, but within those areas of stability, it talks about areas of committed areas and reinvestment areas, and everything really kind of falls into one of those two categories or on a continuum between them. And within an area of stability, like is the case here, under either of those committed areas or reinvestment areas, Blueprint Denver places limitations. It allows some infill, but it also places limitations on those by limiting it to what they call modest. I think targeted is another word that's used in Blueprint Denver. So this simply isn't a carte blanche to do whatever you want, wherever you want. It also talks about addressing issues on the edge of an area of stability that borders on an area of change, which is the case in this instance as well, in addition to addressing issues on arterial streets, which is also a fact in our case. So here we have a single lot on an area, on the edge of an area of stability, bordering an area of change on an arterial. It is modest in scope. The applicant reduced the density to 75 units, a 3-story height, and Blueprint Denver, it meets those guidelines, which are, I think, limited in the sense of trying to maintain character while allowing some infill development, which is the entire purpose of the comp plan and Blueprint Denver. Justifying circumstances is the last issue that I'll talk about, and that is a little bit of a legal interpretation issue. Plaintiffs are arguing that the word land or its surrounding environs means the entire neighborhood. Well, that's just not consistent with our concepts of interpretation, because if you include the entire area within the word land, then the words surrounding environs have no meaning at all. And here we have, as I mentioned before, we have areas of change across the street. We have the identical zone district right across the local street Cedar. I think it's to the south of this particular project. There are a variety of other zone districts within the immediate area here, including a large apartment complex, another development up the street, townhomes behind this unit. There's simply nothing about this rezoning that isn't consistent with Blueprint Denver. And so I'll defer to our briefing on the rest of this, and I'll wrap up by
Counsel?
asking the yes.
I'm sorry, before you do that, I have a question about another criteria for a map amendment, a zoning map amendment, which was the public health, safety, and general welfare. As I understood the briefing, the city's position, and I don't know if you're going to speak for the city or not, but is that the city will not consider traffic or parking issues when discussing or just determining whether to adopt a zoning map amendment. Is that true? And if so, why is that so?
I don't think that's exactly accurate. I'll defer to Ms. Davis if I misstate this, but the city's position is that zoning itself inherently isn't about traffic. It's about land use. And so as an inherent concept, it's not obligated to look at traffic issues. However, public safety and welfare, can conceivably involve those issues if they're brought to the city's attention. And the zoning code requires the city council not only to consider the recommendations of CPD, but also anything that is brought to its attention through the public hearing. So it's a bit of a red herring in this context, because it's clear from the record that there was plenty of evidence presented on traffic issues. At least one of the council members discussed it and found that he didn't think that it was problematic. And the code required city council to take those comments into consideration. So I think it's misleading to say that city council won't consider traffic issues as part of a map amendment. It's not inherent in the idea of zoning, but it certainly was brought to their attention in this case and considered.
So
go ahead. The record does reflect that some opinions there would be more traffic with the townhomes than there would be with the apartment.
I believe there was testimony with regard to a traffic study that was done that found that would be less or roughly a 1% impact, I believe. There were comments from one council member saying that he considered the traffic. He knows people are concerned about it, but he doesn't find it to be problematic. So there is evidence in the record on the traffic issue, coupled with the code's requirement that the city council consider the evidence that is presented to it. So we ask that the court find that the city council didn't abuse its discretion in acting on this map amendment. Thank you.
Thank you, Mr. Schoenberger.
I want to touch on a few questions the court raised and briefly address a few points. First, Judge Navarro, yes, Councilman Sussman was present for the entire hearing. You have the video of this almost 7-hour-long hearing as part of the administrative record, not that you need to watch it, but you'll see that she was an active participant. Indeed, in the Denver City Council, there has long been a tradition of courtesy zoning where the councilwoman whose district is affected gets great deference. This was one of the first times that the council did not give deference to that person. She spoke first, and she fully participated. In addition, you asked about Rule 57. Our spot zoning argument would be a good example of a claim under Rule 57. Spot zoning is a common law concept that we raised both in the district court and this court, where a rezoning must be part of a comprehensive plan. There isn't recent appellate case law on this. The Clark case from the Colorado Supreme Court is almost 50 years ago, but this could be an example of spot zoning. It is the optics today of the city leaving it to developer to defend the indefensible here is quite interesting. The city doesn't speak to defend what happened here. The city's position in this court is absolutely clear, as it was at the hearing, that it does not consider traffic and parking, and I consider that appalling and ask that you do too. Page 34 of the city's brief specifically states that in the middle of the page. This is their answer brief in this court. The city's position is that the city council and planning board do not need to consider potential traffic and street parking issues as part of this element, referring to general health and safety. There's no other element where they do consider those. And the fact that members of the public talked about traffic and parking is not a reason to say it was considered, which is what the developer's argument is here. That was the primary concern, because people are troubled by the city plopping high-density developments in residential areas with no care about how that will affect traffic on city side streets on already congested areas. So don't accept the double talk. Albus Brooks was the council member at the city council who said that is something we are instructed not to consider. Similarly, Joel Noble at the planning board told everybody, all I'm hearing about is traffic, but I can't consider that. That's because that's the city's policy, and we ask you to give them directions that that's arbitrary. There was some brief discussion about plans and about Blueprint Denver. How is a person supposed to move into this area and look at Blueprint Denver and have an idea of what's predictable based on the language of that plan? In fact, all that a person would have seen in 2010 was Blueprint Denver calls this an area of stability. Yes, Blueprint Denver might allow infill elsewhere in the city, doesn't tell you where. And in 2010, single-family rezoning had just been reaffirmed in a public process. So plans need to be predictable. The city has small area plans, and it uses them. Didn't have one here because this area didn't require that. And finally, on campaign contributions, we suggest zero tolerance on that. The Caperton standard is a realistic appraisal of psychological tendencies and human weakness. You want precedents in Colorado that tell quasi-judges no contributions, and Denver needs to design a procedure that allows that. Thanks for your attention today.
Thank you very much, Mr. Curran. Thank you again, Mr. Schoenberger. Thank you, Ms. Davis, for your presence this morning. The case will stand submitted, and a written opinion will issue in due course. As I mentioned before, we will now take a brief recess in order to reconstitute the division, and we will be back in session very shortly. So the bailiff may announce a brief recess.